Eno Extreme Media UJ. Subscribe for all updates.
Thank you very much. All right. Thank you very much, Treasurer and Council colleagues, for managing this business. I think it's now confirmed we shan't have the Vice President for this item. I can, on his behalf, inform Council and the membership and the public and the media as follows. The Vice President reports that a commitment we made to Madame Barbara Kyagulanyi on the 23rd of January this year has been partly fulfilled. Uganda Law Society has taken the step now to file a suit over the siege at the Magere residence of Honorable Robert Kyagulanyi. That suit is being filed at in the Chief Magistrate Court of Kasangati. At Kasangati, it's miscellaneous cause number 30 of 2026. Uganda also the Master Attorney General. It seeks a series of declarations and orders. Briefly, a declaration that the deployment, the encirclement, the blockade, the surveillance, the continued presence of armed personnel of the Uganda Police Force and the Uganda People's Defense Forces at, around, and within the residence of Honorable Robert Kyagulanyi Ssentamu and Barbara Kyagulanyi Itungo constitutes an unlawful restriction of personal liberty and interference with the right to privacy in violation of Articles 23 and 27 of the 1995 Constitution, a declaration that the impugned actions amounted to a de facto house arrest imposed without due process of law and unconstitutional, illegal, null and void, a declaration that these cumulative acts are inconsistent with the constitutional duty imposed on all organs and agencies of government under Article 20, Sub-Article 2 of the Constitution to respect, uphold, and promote human rights and freedoms. A declaration that these actions are disproportionate, unjustifiable, and not demonstrably necessary in a free and democratic society within the meaning of Article 43, Sub-Article 2C of the 1995 Constitution, and an order directing the immediate cessation of the unlawful siege at the Magere residence of the Kyagulanyis in Magere village, Pewo parish, Kasangati town council, Wakiso district. The Vice President reports that Council is pleased to have received services of Council Benon Makumbi Goa, who has led the preparation and filing of these efforts in conjunction with our legal aid project, led by our most perpendicular top gun, Miss Makumbi, Miss apologies, of course, Miss Shiatria Singura, Miss Mariam Takuba Nansupsa, our head litigation, top gun, Mr. Robert Jurua, and others that have contributed. I think several interns that have contributed in assembling this historic matter. So the second thing related to this, we made the second commitment to the Kyagulanyis to explore universal jurisdiction in terms of accountability, since the government of Uganda has failed to offer them meaningful accountability as citizens for gross human rights violations that they have been subjected to in the course of the recent elections. The Vice President and I think have made commitments in this regard. One of them is that we have actually filed a case in the East African Court of Justice. That was, I think, on Monday. The case is called Uganda Law Society. Okay, let me get that clearly. Jointly with the East Africa Law Society. Jointly with the East Africa Law Society, our Vice President has been able to ensure that we have a case filed in the East African Court of Justice over the recent elections. Its case number is reference number 9 of 2026 at the East African Court of Justice, First Instance Division at Arusha. The Uganda Law Society, together with the East African Law Society, have sued the Attorney General of the Republic of Uganda and the Secretary General of the East African Community. Concerning the violations of the rule of law, democracy, and other treaty principles, in the violations of the the Treaty for the Establishment of the East African Community, in terms of in relation to the election that we have just gone through, which we monitored. I think the report is supported by, among others, the election monitoring report of the Uganda Society. That's the Vice President would have spoken on that. The Vice President, I think the third pledge and commitment we made to the Chagulanyis is the national dialogue on enforced disappearance and habeas corpus. Colleagues, as you are aware, this is one of the business on which the Vice President is working. I don't know how far he has gone, what he has reached, and what challenges he is facing, but the dialogue is on the program of the BA, and the Vice President is in charge. At this juncture, I would like personally to thank Honorable Babu for ably bringing us up to speed with the BAC priorities that are connected to the recent election. You were very articulate and genuine and clear in stating the position of the BAC. I endorse, associate with it myself. Then the Vice President also would like to report that there's another suit that has been filed in the South African Court of Justice concerning the recent closure of the NGOs, non-government organizations, by the NGO Bureau, 9th, 10th of January. So this case has also been filed in the South African Court of Justice. The case number for that is, let me put it on record, allow me to get it properly from his. That is case number. Sorry. Secretariat, is there someone from Secretariat help me? Do you know why it's taken leave? Forgive me, colleagues. Democracy must mean the same thing to all signatories to the UN Charter. There must be no the tenets of democracy, including freedom of expression. That as long as Uganda signed on to the UN Charter, the International Covenant of Civil and Political Rights, its aspirations, its binding aspirations for the citizens of Uganda must be the same. How much democracy to permit Ugandans that are being required to, colleagues, it is not easy for Parliament to marshal quorum under the test the court established in Wakisomira Growers. And, it's not easy. The court insists that every vote must have 5 items: the number of parliamentarians present, how many of them are ex officio, so that we can then know how many of them are entitled to vote. And of those who are entitled to vote, how many have voted yes in favor, how many have voted no, and how many have abstained. That numerical record must be ascertained in the Hansard against the decision of the Speaker, the way we see it in the US Congress and the way we see it in the House of Lords. The court, for a long time, Parliament has used other means. So that insistence with the court holding that line and saying, we are going to keep this guardrail. Don't take us for granted. That's a massive step change. Wakiso Mira Grower was a massive step change. It built on an earlier case, the Paul Kawanga Semogere case, which had used more directory language. It had disapproved the use of ayes and noes. It had said, we don't think that conversion can pass the test written in the law under Articles 88 and 89. But now that's the law. So that guardrail is a citizen's victory that is substantial. The second one on substantive is doctrinal purity, doctrinal clarity, simplification of these principles on freedom of speech. They're not easy. So yes, here I would like to disagree with my colleagues, Advocate Chiza and Mr. Natif Tony, that there is not a significant step change on the substance. Despite, first of all, the case of Obo was the tip of the spear for freedom of speech, freedom of expression, freedom of opinion in Uganda, and I believe the English-speaking judiciaries of the Global South. It's that important. That's why even in Kenya they cite it, South Africa they cite it. So its major contribution was that democracy must mean the same thing to all signatories to the UN Charter. There must be no accommodation for local circumstances when we are defining the tenets of democracy, including freedom of expression. That as long as Uganda signed on to the UN Charter, the International Covenant of Civil and Political Rights, its aspirations, its binding aspirations for the citizens of Uganda must be the same as those in quote-unquote mature democracies, so that with democracies there's no catching up. So I think the government had appealed, arguing that it should be permitted a wider margin of appreciation to determine how much democracy to permit Ugandans, that are being required to allow so much democracy, is not the meaning of the covenant. The court said, no, we disagree. You can't prove that you need an exception under Article 43. Although human rights are not absolute, freedom of expression is not absolute, the guardrails that are accepted internationally must also be obeyed by you. So you will not depart from the standards willy-nilly whenever you want. So, well, that decision, every decision in 2023, on the 6th of January, in the Karamaji decision, the Court of Appeal, revives that standard and says that we farm to the standard in Obo against. And Justice Kakuru, of course, did justice that case. I agree. So what then is the step change here? The step change then here is that it's twofold. And colleagues Aaron, Natif, hear me out. The first one is the author of the lead judgment here. It is neither, first of all, it's a woman. That's a significant observation. And which kind of woman?
Abalungi abatuuliriza era abatulaba olunaku olwaleero tuchaddeko ewa Sheikh Asiraf Dembe.
Sebo sanyusa okubalaba amannya agange nze Sheikh Asiraf Dembe akola ku bizibu by'enjawulo omuntu singa aba alina ebirwadde musomereddwa tumuwa amazzi ga lukuya nga bw'obadde ogalaba tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa ne waba atatuuse nga mpadde amannya ge naye ng'ali wala maneetaaze enamba yange yeno eri 0707363711 namwe banyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku dduwa ng'olina ebizibu viza zibuze amaka gakolongotana sente zikola zimpita mu ngalo ojja kumpeereza ekifaananyi kyo n'amanyago ebyo byokka bijja kummala nja kulombera edduwa ojja kutereera olunaku olusembayo mu mwezi mba n'edduwa eyawamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.